Well, despite this next step of reopening, employees may continue to face changes in their jobs. So what are a worker's rights if significant changes continue to be made because of COVID-19? Employment lawyer Alex Lucifero joins us now to talk more about that. First of all, Alex, I guess, can a company make a change to somebody's job because of COVID-19?
Well, in essence, they can't, Matt, or at least they can't make a significant change. So certainly minor changes, changes in the ordinary course of day-to-day employment that are not significant are probably okay. But any kind of significant or substantial change is going to be a problem for employers, whether it's due to COVID or not. The reason why is that an employer can't make a significant change to the terms of employment without the employee's consent. So if an employer is going to change hours or change an employee's pay structure, they're going to need employees' consent in order to do that. And if they don't have the employee's consent, it could lead to issues and potentially even having to owe that employee severance pay.
So again, employees can face a lot of pressure, especially right now if they haven't maybe been working or they need that job. So what happens if an employee accepts, a change, one of those that you just mentioned?
Well, if an employee accepts the change, it's obviously because they see some value in it, some benefit in it. Certainly changes that are beneficial to employees, by all means, go ahead. What we're seeing in the workplace, Matt, is employers having to make significant changes to the terms of an employee's employment in a negative way. So whether it's a reduction of hours, even potentially laying that employee off. We've certainly seen plenty of temporary layoffs over the past year and a half or so. Any negative change that's going to impact an employee that significantly, again, is a major problem. That employee can treat that change as a termination. It's what we call a constructive dismissal, and obtain a severance package from the employer. Again, only if the change is a significant one, and therein lies the legal analysis and ultimately the friction between employers and employees.
Right, and that's where it can kind of get, I know, a little bit murky sometimes and trying to figure out which side and how significant of a change it affects it. If someone doesn't, an employee doesn't want to accept a change, what should they do?
Well, they should very professionally and even politely voice their opposition to the change. So step number one is to tell your employer, I'm not comfortable with what's happening here. I'm going to need a little bit of time to think about this and get back to you. The second step of that advice is going to be to speak with an employment lawyer. You don't know whether a change is significant or substantial enough to really protect yourself in the employment context. So what you want to do is get that professional advice, again, from an employment lawyer, so that you are armed with the information, armed with the knowledge you need in order to then stand up for your rights, which is, again, to oppose the change.
Alex Lucifero, we always appreciate your time when it comes to these issues. Thank you, sir.
Thanks for having me, Matt.